The President of the Republic, Nana Addo Dankwa Akufo-Addo, and the Speaker of Parliament, Alban Kingsford Sumani Bagbang, cannot agree on what the law on injunctions is. The President has a position. The Speaker, who is also a lawyer just like the President, disagrees. Can the President be injuncted in the performance of his constitutional duties? Can Parliament, the Speaker, be injuncted by a court in the performance of his constitutional duties? The Anti-LGBTQI+ bill is the reason for all the trouble. Is the reason ministers who have been vetted have not been approved. Is the reason loans that the government needs have not been approved. We settled the question right here on Newsfile this morning. Who is wrong and what is the way forward? The PURC, through a report issued by PricewaterhouseCoopers, indicts the ECG for a number of non-compliance issues, including not complying with the directive of the President. But is it true that a whopping 1.9 billion Ghana cedis has been lost in the process? I'm Samson Lardy Anyenini. Stay right here with us, your most authoritative news analysis platform, Newsfile. Welcome. And here is Samson's take. The dome versus the doom. The 20,000-seater fantasy dome in Accra, which has been operating for 5 years now, has been flattened by bulldozers. Leslie Queno, the owner, weeps over the destruction that has left him unable to salvage anything, expensive equipment and air conditioners. He's traumatized how he could lose what he says is his millions of dollars of investment, and without a court order. At the time, he had sued the trade fair and managed to serve an injunction motion on them. He reports that he had been called by national security over his inability to relocate and request for more time to do so. And that he brought the court processes to their attention. So he had hoped that in a democracy of the rule of law, such as ours pretend to be, his investment was protected, even if for a short period. Leslie thought his property could only go down under a demolition order from the court. But he was wrong. The courts are prohibited from issuing any such orders, as they are not backed by law. Former Chief Justice Kwesi Anin-Yeboah had calls to issue a directive to all judges to that effect in May 2021. By the rules, orders 43 to 45 of CI 47. That's the High Court rules. A court, upon declaring one victorious in a land suit, is simply to make orders giving that party, the victorious party, vacant possession of the land. In law, land is defined to include any building on it, So it is the choice of the victorious party to decide what to do with any structure on a land they have been declared to be the owners. My concern is not about the imprudence in sinking $1 million into developing a land to which you hold such glaringly questionable title, ownership, if any at all. It is difficult to appreciate why managers of the trade fair and the national security watched and allowed the property to be erected in the first place. Raymond Archer's business on that enclave suffered a similar fate. If you won't grant Leslie extra time to pack out, as he says he was about doing, and if you won't grant him access onto the property, does common sense, humanity, and reasonable conduct not dictate that you take an inventory of his belongings, remove and take custody of his equipment, the air conditioners, and what have you, and require that he pays the cost to recover his belongings? I thought that would be a no-brainer. That you take a bulldozers onto the property and destroy everything on site. But what happened to the Republic versus Moffat and others, ex parte Alote, 1971? Justice Aban held that, quote, I would be laying down a very dangerous precedent if I were to hold that a party, when served with an application for an order of prohibition from the High Court, that is injunction, can disregard or ignore the said application and treat the court with contempt, end quote. This is what has become the general principle of law on the effects of a filed, served, and pending injunction application. This is the very same law and principle the Attorney General and the President has urged on Parliament. The Attorney General and the President say the application for injunction alone, once it is served on you, should operate to stay your hand from doing anything to the disputed property. And that, we know, is the law, according to Moffat. National security does not agree with its legal advisor, the Attorney General, and the Commander-in-Chief. They don't. Maybe those at that place, the trade fair and the national security, will be fired for their contrary conduct, especially for a business that was already packing out and pleaded for a bit more time to do so in the face of being declared a trespasser onto the dome property by the managers of the trade fair, as he alleges. And that is my take. Let not only be lawful, let's be considerate, and let's act swiftly when we have to act. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. And my panelists for this first segment of the discussion, Godwin Kujo Eduji Tameklo. He's Director Legal, Directorate of the National Democratic Congress. We also have here Joseph Dindiok Pemka, who is former Deputy Attorney General, Minister for Justice, and former MP Tempane. Bobby Banson is also a lawyer and author of legal texts. He also teaches the law. He is also here with us on the program. Gentlemen, good morning and welcome to Newsfile.
Good morning.
Good morning.
Great to have you. Great to have you.
Yeah.
Right, so let's take a quick trip to Parliament to remind ourselves of the things that happened on Thursday. As you may well know by now, the presidency issued a letter under the hand of the Executive Secretary to the President, Nana Bedietio Asante, to the Clerk of Parliament. Apparently, Parliament had attempted on a number of occasions, at least 3 times, we understand, to serve the bill, the anti-gay bill, on the president after it had been passed by unanimous votes in the Parliament of the Republic of Ghana. They were transmitting it to the president so he will do his Article 106 duty. Article 106 requires the president that when law is made from the representatives of the people, it shall be transmitted to him. And when it gets to him on his decks, a certain number of days begin to count. He has within 7 days to indicate if he's going to assent to it to become law, or if he will not, he should give his reasons and take that through the Council of State within 14 days, and then another process will begin. The presidency has refused to accept the transmittal because they say there are 2 suits against the bill and the manner in which it was passed, or the constitutionality of it, and that there are injunction applications, and therefore they want to uphold the law by not accepting the bill. That has brought trouble. The Speaker of Parliament had a view on this matter.
Unable to continue to consider the nominations of His Excellency the President, to use the language of the Attorney General and Minister for Justice, quote, in the spirit of upholding the rule of law, unquote, until after the determination of the application for interlocutory injunction by the Supreme Court. Honorable members, this is the precedent that is being set by His Excellency the President for all Ghanaians to follow. So any matter that comes before Parliament, any Ghanaian can issue a writ and follow it with an application for injunction. And that is enough to injunct Parliament from proceeding with the consideration of the business in the House.
The Constitution of Ghana spells out in plain language when the President of the Republic of Ghana must do when Parliament passes a bill and present to His Excellency the President. The President must assent to the bill or must refuse to assent to the bill when it is presented to him as the President of the Republic. These are the only options. And in this case, there is no middle ground at all per the constitutional imperative. Ladies and gentlemen, let me also say that in the instance case of the Human Sexual Right and Family Values Bill 2024, President Akufo-Addo has taken a strange and alien position, which is unknown to the Constitution of the Republic of Ghana. Given that Parliament has been injuncted in a matter of the President's nominee for the position of ministers and deputy ministers, it is obvious that this honorable House is also unable and cannot approve those ministerial nominees His Excellency the President has also presented to Parliament.
We in the majority beg to disagree on the position taken by him. If you carefully read the letter that was sent to Parliament, Mr. President limited himself to the processes before the court. And the fact that Parliament itself, through an affidavit, had joined issues. Parliament has filed an affidavit in opposition and is in court. In fact, Parliament is a party to the suit. So for us, we do not see how this would have to affect the proceedings of Parliament. In any event, Mr. Speaker has always deferred to the leadership of the House to guide him in the conduct of business. This morning, the leadership of the House sat together to discuss the various items to be taken. We have finished some of them. There were some that we were supposed to take, and we're told that Mr. Speaker would have to take the chair. It's very disappointing that after Mr. Speaker had made known his own views about the letter sent from the presidency to the clerk, he adjourned the House Synod without giving room for the leadership of the House to even comment.
We may have issues with the letter, people may put interpretations, but anyone is entitled to, as it were, proper ideas or proper suggestions or give out opinions on particular things. So I would want to treat the letter purely as an opinion written from the office of the president to Parliament. Parliament can decide to proceed by sending the law. It is up to the executive to decide not to sign the law because of its interpretation. Now, my understanding is that the letter is probably trying to interpret the law, that in the circumstances of the pendency of the injunction, if the bill is brought to the office of the president, this is going to be the reaction. But the most important thing is all the organs are performing their respective legitimate functions and duties. Problem about the character of injunctions and the principles of injunctions under Ghanaian law is that anybody at all can freeze anything by merely bringing an application to court.
And that's Professor Kofi Abuchi, Dean of the Impasse Law School, and here in the studio.
UPSA.
UPSA. I'm still at GIMPA with him, right? Okay. So Professor Kofi Abuchi, Dean of the Law Faculty of the UPSA. Here in the studio, Bobby Banson, he's a lawyer, he's a law teacher, he's author of legal text. Eduji Tameklo is Director Legal of the Opposition NDC, and Joseph Demdiok Penka is former Attorney General, Deputy Attorney General and Deputy Minister for Justice and former MP for Tempane. So it's, if you like, a law file once again this morning. So let's go straight to the question of the attempt to transmit the bill to the presidency and the presidency's reaction, and then the speaker's reaction. The speaker says the letter is contemptuous of Parliament. Aduji, you see, right?
The Speaker of Parliament, recognizing that we have three co-equal arms of government, and the fact that the legislative function relative to the passage of a law does not terminate even when the bill is transmitted to the president. I think the posturing, the tone of the letter written by the executive secretary to the president, particularly the portion where it says cease and desist, is beyond it being contemptuous. One can even describe it as completely unlawful. Because you see, Parliament is in its lawful business of just transmitting the law to the president. In fact, you will recognize that under Article 106(7) of the Constitution uses the word presented, the transmission mechanism. It is when the bill so passed is transmitted to the president, he takes possession of it, he can then decide that I want to assent or not to. And the law specifically give the indication that when the president decides that I will not assent, what he should do. We are not being told that the president has taken possession or custody of the bill so passed and has come to the conclusion that on the basis of the pending suit, he's unable to assent. That is a different kettle of fish. At this point, we are still living in the mechanism, the process of just conveying the process to him. On what authority is Mr. Bedietuo Asante purporting to issue that letter? On what authority? On what statutory or constitutional basis is he putting up that letter? You see, it is becoming one too many. A process that I'll describe as sheer misconduct. If you recall, in this studio, you discussed this matter rigorously. The issue of Domelevo having to go. You recall that incident? It is the same Bedietuo who, purporting to act on the instructions of the president, asked the man to proceed on leave. For the first time in many years, the Supreme Court had the opportunity of describing the conduct of the president, again, conveyed by the same Asante Bedietuo, as unconstitutional. And in fact, if you read my Lord Justice Nene Amegache's judgment in the coalition of, this is how he described the president's conduct. In this case, the presidency failed to consider that the Auditor General's office as the head of the audit service form part of the independent constitutional bodies. Hence, the Auditor General cannot be compelled to proceed on leave by any authority, especially where the effect of the directive was to interfere with the performance of his constitutional mandate. Today, our courts have found that our president, Nana Addo Dankwa Akufo-Addo, obviously acted unconstitutional in purporting to act Domelevo to proceed on leave. Now, is it not curious that where you have a president who is even a lawyer, one would expect a certain level of sobriety, a certain level of sober reflection, and taking decisions that have ultimate grand impact on how our governance structure. Look at the tone of the letter.
Cease and desist is English.
No, it is a threat. You hardly use that language. Any moment Samson Lardy uses that letter to somebody as instructed by your client, that person carries a certain level of consequence. It means that if you proceed, so it's actually a threatening letter. The tone, the language does not befit the office. And you see,
Parliament attempted, at least we now know, about 3 times to transmit this bill to the presidency. When Parliament was aware that there has been a suit, there have been suits, at least there is one by Richard Sky, and that there is an injunction application pending. And part of the reliefs that are being sought is that they are seeking the court to prevent the speaker from transmitting the bill to the president. It's one of the reliefs. Is Parliament not aware? So why did it go ahead to want to transmit it?
First of all, if you look at the reliefs that Amanda Odwe, is that the name?
Yeah, that's the 2023 suit.
Exactly.
We are talking about Richard Sky.
No, I'm coming. I'll deal with it too. You see, when Parliament is transmitting the bill so passed to the presidency, Parliament is still in this legislative function. Mm-hmm. In fact, after the president is even done, assenting, the legislative function doesn't end, because the president would have to transmit the bill that he has assented back to Parliament. Then the clerk will now do the numbering. It is the clerk that will say it is now called Act 223, Act so.
And then proceed to gazette.
And then proceed the gazetting. So even when the president purposes to even assent, the legislative function doesn't end. There's still a chain You understand? Now, when Amanda took the speaker, among others, to the Supreme Court, the Supreme Court said, look, that legislative process is still in process. So we are unable, under the circumstance, to injunct the process. And to the mind of the court, a prima facie case has not been made. That is in the ruling delivered in July 2023. Now, Richard Sky, again, was seeking to stop Parliament from the transmitting. At that point, Parliament was just organizing its constitutional mandate. The Supreme Court has gloriously...
The time Amanda's injunction application was refused last year,
yeah.
Was it June, July?
Yes, July. In fact, I made a point. July
Right.
2023.
Right. She was questioning the processes to pass it.
And
And the court said, we can't interfere until they are done.
Sure.
Okay? So you have come prematurely. Absolutely. The bill is done.
No, I am saying that.
In this instance, the bill is finished.
No, the legislative process has not ended. The legislative process has not ended. In fact, like I indicated earlier, when the president even assents, it must go back for the gazetting processes and all of those things are not done by the executive.
Did she have a specific relief to stop Parliament in transmitting the bill in the manner Richard Sky had? No.
No, Richard Sky was a bit more specific.
Correct.
Relative to the
So
process.
it says, don't transmit it.
Relative to the... But I'm saying that if you look at the overall conduct, unless, of course, the president has the liberty to decide which court process to respect and which one not to.
That's another argument.
No, but you see, the point ought to be made that I, Eduji, was the counsel for the then minority leader, Haruna Idrisu, Samuel Okudzeto Ablakwa, Mahama Ayariga, when we challenged the constitutionality of the e-levy law. At the time we're in the Supreme Court, right, the president was assenting to the law while the matter was pending at the Supreme Court. Unless, of course, we are saying that the president has the liberty to be hypocritical.
Okay.
Has the liberty to demonstrate a certain level of duplicity.
Right.
That cannot be the case.
It
is either respectfully that you respect that any time a matter comes to your attention, you must cease. And I give you a classic reference. During the NDC primaries, one of the candidates, the presidential candidate, one of the candidates took the whole process to court. Then the EC says, having been served with the process, they're unable to proceed. We said, okay, no problem. Through dialogue and others, the process was withdrawn. The EC came and conducted. Then, during September, the decision to do the limited registration, I issued a writ on behalf of the political parties. The EC was duly served with the process. They still went ahead. I am saying that what democracy...
In fact, a couple of other citizens also issued...
Absolutely.
The EC went ahead. So we are not talking about the duplicitous conduct of officials in this direction.
Sure.
What I'm asking now is, from what you know, okay, the relief was that he should be stopped from transmitting it to the president. Should the speaker or should Parliament have attempted to transmit it in the first place?
I do not see any limit relative, at least for whatever is worth. The Richard Sky had the benefit of applying for contempt proceedings against Speaker or the clerk, that pending this matter, they have taken ABCD steps. As we speak, no such intervention from Richard Sky had happened. I am saying that that option is available. If you look at the ex parte Benjamin Dufour position of the Supreme Court, it may well be that any conduct that has the potential of undermining the administration of justice can be deemed contemptuous. But in this case, that conversation had not even come up. I am saying that the tone, the language of Nana Asante Bediatu, beyond it being blatantly, it's not grounded in law. I did not see the legal basis of that, what do you call it?
Okay.
And you see,
so I'm getting you to the specifics. So yes. Now flip it this way. The Speaker says, on the other hand, I have been served with a process that seeks to injunct me, the Speaker, from going ahead, or Parliament from going ahead. The Speaker is actually a party who has been sued, from going ahead with the approval process for the ministers who have been vetted. On that score, I will respect the court. I won't do anything. Was the Speaker wrong?
I won't say the Speaker is wrong. But you see, I like the fact that the Speaker puts himself in the mode of the President.
So if the Speaker is not wrong,
yes,
is the President wrong?
You see, I have made a point about the cease and desist.
No, we have moved away from that.
No. You see, for me,
I want us to keep ourselves within. Let's keep ourselves within the suits.
No, the point is that the letter from the presidency should be construed as a whole.
So we have dealt with the letter.
It's a full package.
No, sorry. So you have dealt with the letter. I want us to constrain ourselves to the context of the suits.
Very well.
If the Speaker was not wrong, as you say, and you believe that is the law, correct?
That should be the law.
The President was also not wrong, was he?
That
he's been served an injunction application. And it is
what?
as good
To do
as
what?
an injunction.
No. First of all, the Bediatuo letter is not communicating the President's refusal to assent. That's a different matter.
It's communicating refusal to accept and to assent.
Good.
Because the reliefs include thou shalt not transmit.
Good.
So the one to accept says, you have been asked not to transmit.
No.
I will not accept.
No, don't. So that way.
And if I accept, I am supposed to assent or signify my refusal. The relief also says, thou shalt not assent.
No. First of all, the substantive relief relative to transmitter is not directed at the President. It's directed at the Speaker.
Correct.
And so, therefore, you cannot be telling the Speaker that don't transmit. If the relief says...
I am being prevented, from a wrong.
If the relief,
I'm being prevented from a wrong.
Relief,
you are saying that you should countenance the wrong, knowing that I am being prevented from it.
No. If there was a substantive relief,
saying,
Mr. President, do not accept the transmitter of this letter to you, then you can say, there is a relief preventing me from conducting myself in a particular way. There was no search in Richard Sky's process. So the President cannot use that as a rule to prevent Parliament from conducting its constitutional responsibility. If the process had gotten to him and the President is minded not to assent, then the President can say, having become aware of this, I am unable to put my signature below it.
So you hold on. Yes, Penka. So as far as Eduji is concerned, the Speaker was right that if he has seen a process, and we know the facts by now, the Speaker has not seen an injunction application. Because by the time the Speaker, on Thursday when the Speaker said, I have seen an injunction application,
there was none.
One had not been filed, okay? Even if it had been filed, it had not been served. We know by the record that it was rather filed on the Friday, correct? At 10:15, correct? No, that was a Wednesday and on the Thursday.
10:15.
Right. 10:15 a.m. So, Eduji says, the Speaker was right. Once he has seen something like that, he cannot continue. The law is that you stop. But the President was not right. Having been served with a similar process, served on the Attorney General, and the Attorney General brought it to his attention, he should not be saying he cannot, he cannot accept.
Thank you very much. Thanks to your cherished viewers. Samson, it's a very interesting discussion we are having this morning, and the expose and exploration we are making into the legal realm is going to help strengthen our democracy. Now, this is my take on the matter. You've spoken about the transmittal. You've spoken about the conduct of Mr. Speaker and the letter coming from His Excellency the President. Samson, before I actually proceed, I'd like us to read the second paragraph of the letter from Nana Asante Bediatuo. the second paragraph. And it says the office is aware of 2 pending applications for an order of interlocutory injunction, both filed on 7th March 2024 in the Supreme Court in Dr. Amanda Odoi versus the Speaker of Parliament and the Attorney General on the 11th of 31st 1/3/2023, Richard Sky versus the Parliament of Ghana and the Attorney General, respectively, to restrain you and Parliament from transmitting the bill to the President, and also to restrain the President from signifying the assent to the bill pending the final determination of. That's the second paragraph. So the cease and desist takes its precedence from the second paragraph. He's saying that don't send it to us. Cease and desist. Why? Because there are pending applications seeking to restrain you.
There is a pending application, not pending applications.
There is a pending
application. And again,
seeking to restrain
again, let's also expose that faulty and false claim by the presidency. There was 1 injunction application pending.
Absolutely.
Amanda's application had been determined in July.
Yes, I'm reading the letter in its totality.
Right,
That's why I want to put it within.
That's correct. That's correct.
So, if you look at Richard Sky's reliefs, very clear. Do not transmit. Okay.
And if you get it, you too don't signal.
Don't sign.
Don't assent.
Yes. So you see, then we got ourselves into this situation, and so you know the principle. You've already stated the principle clearly in ex parte Mufat, and it's very clear.
Ex parte
Alote, sorry. It is very clear that once that is brought to your attention, even not served on you, even if it is brought to your attention, but it's not served on you, and you take actions that will seek to defeat the purpose of it, of course you'll be in contempt of the court. But you see, there's a novel situation that we found ourselves in. And I think that there's a very serious matter about this constitutional principle of separation of powers.
That's right.
That we have, which is being played out here clearly, with each of the organs trying to assert their independence over the other because of the 3 arms and all that. If you look at the content of Chapter 8, Chapter 10, and Chapter 11, that if you look at that's Article 57 onwards, then Article 94 onwards, and Article 125 onwards, about the 3 arms. And then the way it is being structured, as far as possible, separation of powers is actually the arrangement that we have in our Constitution, by taking into consideration the fact that each one of them will, at one point or the other, in a way, not supervised as such, but in one way or the other, they are interdependent to be able to run the affairs of the state. So you have a situation where the president says, I have had this, which has come to my attention, and I'm unable to accept the transmittal because the application itself says that do not transmit. And that is why my brother did not answer that when you asked him in all intents and purposes. He didn't answer that question because the relief is saying that do not transmit. So if the relief that is being put before the court says do not transmit and you do transmit, are you not acting contrary to what the relief is seeking? And in any case, if you do the transmittal and it is accepted, then the relief the person is already seeking in court become absolutely of no use before the court because they have already been determined anyway. In the end, the court will just come and say that about what you were seeking to do has already been done. You know, and we have to, as much as possible, avoid that and let the courts make pronouncements in order for us to proceed. Because, again, if you look at the matter carefully and the reliefs that are being sought, both in the substantive reliefs and the injunctive reliefs that he's actually seeking, he states categorically what he wants. And I think that Richard Sky, when I read it, there was some level of brilliance. He tried to go around it to ensure that not only should the thing not be transmitted, but even if it is transmitted, do not sign. And so Asante Bedie too wrote that letter. You may have a problem with the language, but that is his choice of words that he...
So from your knowledge of the law, you have not only been, call it a mere lawyer, you have been the Deputy Attorney General, Deputy Attorney General. The Attorney General himself or herself is supposed to be a leader of the bar. What would be your instruction if you entered the classroom to teach law students? Would you say that the pending application that has not been argued and decided by the court should stop the recipient from doing the things they are being...
I will say so without hesitation at all. I will say so because if the purpose of the application is violated in the course of the transmittal and etc. and the signature, then it's been defeated already. Then what will be the purpose of it? The application will just go to the table and serve no purpose at that particular stage, because the judge will say that what you are seeking to achieve has already been done. So we are unable to make any pronouncement and all. And they've done that quite a number of times. Sometimes even long after whatever they were seeking to injunct or prevent has happened, then the court comes to say that even what you were telling us to do, unfortunately, has already been done. So we are unable to make any pronouncement because it will be of no effect and etc. Several times that has been done. But you see, again, I'm going back to Mr. Speaker. I want to make a comment.
Wait.
Yeah.
If a party who has received an injunction process proceeds to ignore it, and that's the thing that the injunction process is seeking to stop, what is the remedy?
Contempt.
Contempt.
To go by a contempt application.
Okay.
That's the remedy. You know, because if you seek to do something that will defeat the purpose, the contempt application can be mounted against you.
So why don't you want to wait and allow the speaker to suffer the contempt because you are transmitting it, or the
no,
clerk?
But that's another choice, and he made a choice which is also not unlawful. He says that obey it. Let's wait for the outcome. But there's something very interesting I'm coming to actually look at. You see, people are misunderstanding the import of the injunctions filed by Richard Sky and that which has been filed by my good friend Roxanne Dafiamekpo. The two are totally different. And I would like us to, if with your permission, I would like to look at just the content of the two. You see, what Dafiamekpo is seeking to do is that there are a number of ministers whose appointments, according to him, the appointments were revoked.
According to the letter from the presidency.
The appointments were revoked.
Yes.
I'm just talking about the content of the record,
All right.
the suit. Once the appointments were revoked, and subsequently the president reassigned them, he said that that was unlawful, and that the president could have only renominated them for consideration by parliament. Now he mentions the Honorable Henry Kote, he mentions Asen Subwache, he mentions my brother Abanga Abdullahi, and a number of others, and said that by that letter, all the president could do was to renominate them for consideration by parliament, prior approval of parliament. Now, the ministers who were actually transmitted to parliament and vetted do not form part of those he's talking about. All those who were vetted are not part of those he's talking about. So, what is the purpose of that suit? You are seeking to say that Mr. President should have reassigned without revoking, because he cited the authority, which is very clear to all of us, that just reassign, don't revoke, and then reassign. Because if you have revoked, then you have to renominate for prior approval of parliament. And I'm saying that all those ministers he has talked about were not before the Parliament of the Republic of Ghana. They were not being vetted. So, and if they were not being vetted, and the processes and consideration for the president's nominees for ministerial appointment do not include them, to what effect will the injunction?
Who are those who have been vetted?
What I'm saying is that
who are those who have been vetted?
Oh, quite a number of them have been vetted.
Who are those?
You have, of course.
No, not the persons.
Yes.
Which category do they belong?
Those who have been vetted, some of them, in fact, were already ministers. Others were not ministers. Okay, and some. If you were a minister of state and you are appointed a substantive deputy minister, you are appointed a substantive minister or a minister of state, you go for vetting again. Mm-hmm. For example, Abina Osayasari, finance, right. She was deputy, and then she was nominated as a minister of state, so she had to go through vetting.
So we know
now,
that.
If you look at,
can you say for a fact that all those vetted, none had their appointment according to the letter revoked and reassigned?
So that is the point. Assuming without admitting that all of them even had their appointments revoked and reassigned, then they have gone through the vetting process. And so Roxanne Dafiameko's suit will die on arrival. What he's asking for is what has actually happened.
The process is not complete.
Yeah, but that's what he's asking for, which he's seeking to remedy, has actually been complied with. He's saying that, hold it.
The letter from the president, if you just read the first line, it will help you greatly.
No, but
because you see, this is the letter from the president with respect. It says, exit from office. The president of the republic, Nana Addo Dankwa Akufo-Addo, has relieved the following ministers and deputy ministers.
Absolutely.
Let's not make a confusion here. I think that is not in question. The question is that those the president purported to or said their appointment have been revoked, they have not been presented to Parliament at all.
Yes. So what were you? They have not been presented to Parliament.
Do you get the point?
No.
Those he said their appointments have been revoked.
Yes.
And then later said they are reassigned. Those people have not been presented to Parliament at all.
Yes. There are two categories.
No, we know. So that category that Roxanne is challenging have not been presented to Parliament at all.
So, yes.
Because the intention is not to present them to Parliament. And he is saying you must present them to Parliament. No, so the question he's asking now is that those who have appeared before Parliament, they do not belong to the category whose appointments were revoked. So why are you not dealing with them?
But senior, respect to, if you look at the list, there are two categories, ministers and deputies. Question, Fatima Abubakar was a deputy minister of information,
yes,
correct?
Yes.
Has she not been presented?
She has been presented.
You understand?
She has been presented.
At that time, she was deputy.
She was not, her appointment was not revoked.
Yes. It's under the list of those.
Roxanne is challenging those whose appointments were revoked.
I get you.
If her appointment was revoked and she has been presented to Parliament, then Roxanne doesn't have a case.
You get the point?
Good. So the point I'm making is that there are two categories.
Yes.
All these two categories are subject matter of this litigation.
No.
Because you see,
no, they are not.
Let's not confuse
the issue.
The communication from the president, which I have.
If you allow me,
go ahead.
You see, if you allow me, I'll make my point. You see, there are two categories of people.
Correct.
I stated to you that some have not been brought to Parliament at all.
Correct.
And for me,
and Roxanne insists they should be brought to Parliament.
Those people. Yes. He's seeking his release based on those who have not been brought to Parliament.
All right.
And so, if they have not been brought to Parliament and you are going there, then what are you injuncting? What are you injuncting?
Is that not for the court to make a determination?
No, hold on. The people who have been nominated, who have been reassigned, which to you, the reassignment was wrong because there was a revocation. Admitted or without, assuming without admitting that what you said is right. Those people have not been presented to Parliament. So what processes are you stopping in Parliament?
Okay, let's not create an argument there because there's none.
There's none. So I'm saying that, you see, I don't want to sound sub judice in the matter because it is before the courts. But Roxanne tried to cure a mischief, and in seeking to do so, he created a very huge mischief. And you see, the mischief is created deliberately because there's an attempt to equalize. So because Mr. President said, don't bring the thing, if you bring it, I won't even sign because there's a process. Then Mr. Speaker says, in the same way, eat your own, have a dose of your own medicine. But
the Attorney General calls it tit for tat.
Yeah, it's totally different. Because you see, two letters.
Edgy, hold on.
You see, it would be unfair on the part of the Speaker.
Hold on, please. Hold on.
But it would be unfair on the part of the Speaker to create the impression that as at the time he was basing his decision, he was basing a decision on an injunction that is doomed to fail. That's a determination for the court.
There was actually no injunction at the time.
No, but on the relief, at least there was something.
That's a different relief on the rate. That's different.
Relief, no, but you see, the last relief is
the Speaker said.
Yes.
I'm not supposed to be arguing with you. The Speaker said that he has before him a process. Then he reads the title of the suit.
That is correct.
Then proceeds to say that there is an injunction motion. At the time, we know for fact there was no motion for injunction.
But
because it was filed the next day, Thursday at 10:15.
No, but there's an injunctive.
Yes, there's an injunctive relief. We can talk about that later. If the Speaker said, I am dealing with an injunctive relief within the rate, that's a different matter.
Very well.
Good.
You see,
now, hold on. I want to go to Bobby here.
Oh, goodness.
Yeah, sorry, you hold on for me briefly. Bobby, so if we ignored all the inaccuracies and falsehoods in the statements by both sides, and again, I need to qualify when I say it may be false on the part of the presidency that there are two injunction applications, because once the one was dismissed in July, it doesn't mean that the person cannot file another one. So potentially, the person could have filed another injunction application. So it may be the case that there are two injunction applications. Forget about all of that and come to the position. Was the president right? The law you teach your students. Yes, the book you have written, I have read it. again this morning before I came.
Samson, good morning. Good morning to Senior Penkind and Godwin. Yesterday, somebody called me and said Samson may be a prophet, as if he knew injunctions would be a huge issue. Dedicated several weeks to discuss injunctions.
Those discussions on the law, myself with you and my friend Jemfi in Kumasi, I have played them over and again to listen to you guys again. Yeah.
I think that devoid of all the emotions.
Information before this one.
I'm coming. Yeah.
Emphatic you made. A correction has been sent to me.
What's that?
The Attorney General says that, as to let you know, that there's a fresh application for injunction by Amanda.
Okay.
There are actually 2.
Thank you. So that helps it. So there are actually 2 injunctions.
Okay.
When was the fresh injunction filed?
Yeah, I think I haven't gone through, but he stated it.
Okay.
You're not curious.
Okay. All right, let's go.
He is sending this.
Let's go. No. Relax.
No, but it's for correction.
Let's not be preemptive.
Make an emphatic statement.
Let's not be preemptive.
There are no 2 applications.
We should believe the Attorney General. We should believe the Attorney General.
We'll deal with that.
Eduji, in the absence of other facts, we should believe the Attorney General when he stakes his neck to say that there is an injunction, another injunction by Amanda. Thank you. Yes, let's go on.
Okay. Something I would want to lay the basis of my understanding on this whole process, and it stems from the concluding part of your interaction with them. A suit is commenced generally by the filing of a writ of summons. In the Supreme Court, we just merely refer to it as a writ. Then it comes with your statement of case in the Supreme Court. So I'll just simply say a writ of summons. Now, when you file your writ of summons, you can decide to include in your writ any relief that you want. Now, in your writ of summons, it has been held by the Supreme Court that you cannot include in your writ of summons an interlocutory relief. So a writ of summons cannot be endorsed with a relief of interlocutory injunction, because then the action itself could be dismissed for disclosing no cause of action. There's a Supreme Court decision on that. Now, you can endorse in your writ of summons a relief of perpetual injunction. Now, perpetual injunction is the final injunction that the court may award after the end of the case. Now, it is also trite that the fact that you've endorsed your writ with a relief of perpetual injunction does not in itself operate as an injunction. And so if beyond the perpetual injunction, you desire an interlocutory injunction, you don't include that in your writ. And I have seen that in some of the writs that have been filed. A relief for interlocutory injunction and then a relief for perpetual injunction. The Supreme Court says that interlocutory injunction does not disclose the cause of action. So you cannot put that in your writ. So what you can put in your writ is a perpetual injunction. Now, if beyond the perpetual injunction, pending the final determination of the matter, you seek some status quo to remain, or a reversal, so status quo ante or status quo present to remain, nothing stops you from filing an application for interlocutory injunction. When the application for interlocutory injunction is filed, it must be served on the party that you think wants to take the step that you are seeking to restrain.
Can you pause there and help me with the education, my viewers? Status quo ante and status quo present. What does that mean?
Status quo ante means something has been done. You want it to be reversed pending the determination of the matter. So, for instance, you are litigating over somebody with a land. You were in possession. The person has brought bulldozers there. You can file an application for injunction, and you can include or describe it as you want the status quo ante. It means that the status before the writ was filed. And so if there was no bulldozers on the land, you are asking the court to order the person who has brought the bulldozers to take them back. So that before, what the status was before the writ was filed is what you are asking the court to have it maintained. Now the status quo,
the case itself has been determined. And then we get to know who is the winner. Okay.
If the case is determined and the court says who owns the land, then the court will perpetually restrain the loser and all those who claim title through him from interfering with your possession of the land.
Then the other one.
The status quo present is, as at today, that we are going to court and filing my application. The status is that there are bulldozers on the land. The court should...
Or there is a building...
There's a building on the land. The court should order that nobody should take out the bulldozers, but nobody should come and add new bulldozers. So what it is at the time we file the application for injunction or the writ is what I want to be maintained until the final determination of the matter.
All right.
So those are the various forms of the interlocutory injunction that could be presented to the court. Now, if an interlocutory injunction is filed, whether to maintain status quo ante or the status quo present, once it is served on the parties that we are seeking to restrain them, then those parties cannot take any step which will undermine the authority of the court. Godwin referred to the Benjamin Dufour case, and he also referred to the Alote case, the one we say the Moffat. So that is without dispute. Now, in these facts that we have, I would want to deal with Mr. Sky's suit because I have read the writ and then the injunction application. On the 7th of March, he filed the writ with a statement of case and then said that the whole process that the parliament went through breached certain provisions of the constitution. Now, because of that, parliament should be restrained from submitting the bill to the presidency. As Godwin explained, that once parliament passes the bill, it goes to the presidency. Presidency assents, it comes back to parliament, co-minini. Now, beyond filing the writ, on the 8th of March, Richard Sky went ahead to file for an interlocutory relief, asking that pending the determination of the writ, parliament should be restrained from presenting, pursuant to Article 106, I think, presenting that bill to the presidency.
I understand Amanda Odoi also filed the fresh interlocutory injunction application on the 8th of March.
Interesting. To use Godwin's words, curious.
Yeah. Go ahead.
But I have not read that,
All right.
so I'll deal with the Sky's own. Now, once that interlocutory application, and Parliament has not denied that they've been served with it. They have not denied.
That is so.
Yes. So, to all intents and purposes, Parliament has been served. Now, the Attorney General, that is the principal legal advisor to the government, per Article 88, has also been served. Has also been served with that interlocutory application.
Because he's
not
also
the
a party.
He's also a party. Now, if you are aware that there is a pending interlocutory application to restrain a party from bringing you something, and that party brings it to you, and you receive it in the Alote case, you have opened yourself up to contempt. So you may not have been the person that the interlocutory application was directed to. But if you take a step that will aid that person to undermine the purpose of the interlocutory application, you have also aided. And you would also be liable for the contempt. It was clear in the Alote ex parte Alote case. Now the presidency, my understanding from that letter, is saying that I am aware. So if I receive it, I've also opened myself up to contempt. If I was the president, I would not receive it and say, take me for contempt. I will not. I'll say, don't bring it. We may have our different opinion as to the manner and the choice of words used in the letter.
That's a different thing.
That's a different discussion. And I think that the communication from the presidency to the parliament, because of the level of authority they all have, could have been done in a better way.
It showed disdain.
It's too strong because disdain would have to mean there's an intention.
Okay.
I'm not in his mind yet, so I will not know whether that was the intention. But I think the communication, a phone call, a discussion at their level. Remember, the Speaker of Parliament was in Parliament with the President, and they are both senior lawyers at the bar, so they would have had some form of relationship. And I don't think that they don't talk or they've never spoken before. So there could have been some other means of having discussions. But that is another, purely on the side of law.
Yes, I
do not think.
I was asking you at this point, is it your view that the performance of the constitutional function of the executive or the legislature can be injuncted?
So that's a general discussion.
Correct.
Okay. Now, if you look at the ex parte NLA case, which was reported Supreme Court, I think 2009, that Teban was very categorical. You cannot use injunction to prevent the performance of a statutory responsibility. That Teban was very, very categorical. You cannot by means of an injunction. Because you see, injunction is an equitable relief. And it will only be granted if there is no other alternative. It is very clear. That is why they ask you when you file for injunctions, will the damage or will the wrong that you are seeking to prevent, can it be compensated by damages? Or is there any other relief? So for instance, if Article 2 says that any step taken by any person in breach of the Constitution can be struck out by the Constitution as being a nullity, if you seek to prevent that step from being taken, that is your right in a substantive action. But if you bring an interlocutory application, the Supreme Court may, and we are having a general discussion without prejudice to the case pending, the Supreme Court may ask itself.
I know why he's posting the caveat.
Yes, because I don't want to. The Supreme Court may ask itself whether there are alternative remedies. That is key because injunction is an equitable remedy.
What if the person seeking the injunction against the performance of the statutory obligation can show that there is a breach of law or procedure in the process?
I have no doubt that you must first establish you have a legal right.
Yes.
You must establish there's a prima facie case. You must establish the balance of convenience. And you must also...
It is not as of right.
Yes, of course. And also that there is no other alternative remedy. There was a case where, I think it's Abu Ramadan, one of the Electoral Commission cases.
Correct.
Where the Supreme Court said that if we grant this injunction, it will lead to a meltdown. So let's go to the substantive because the fact
that's Ransford, France.
Ransford,
In fact,
France.
When the application for injunction came, this is what my Lord Justice Ansah said. Quote,
in that case?
Yes.
Okay.
The conclusion I come to is that injunctions may not be used to interfere with the processes of Parliament. And as regards to its proceedings within its own war, Parliament is completely privileged from judicial intervention. Completely. And I'm saying that the transmission mechanism is a parliamentary responsibility.
Okay, thank you. So conclude on what you're saying.
Yes, so
I ask you the next leg of that question because the point you made, the general point, is confirmed in the Law of Injunctions, the 11th edition, LexisNexis, and I was reading it. Okay. So, but there is the qualified situation where the officer exercising that statutory obligation or constitutional obligation, so to speak, if there is proof of a breach or violation of law or procedure, then they may be stopped.
But that is what I was going to say, that if, we are still dealing with interlocutory injunction, if this alleged breach of statute is the basis of your substantive application, then the court should not. And you can look at ex parte Mobile.
Okay.
They said, I think 2005, 2006, Georgina Wood, he said, if what you are asking us to determine by this interlocutory process would result in us making conclusions that will affect
resolving the
substantive matter, we will not. So if you say that there has been a breach, and that is why you are seeking substantive relief, the Supreme Court will not entertain an interlocutory application.
Okay.
That would delve into the substantive relief.
All
but
right.
I think
do you think, does it
privilege Parliament?
Does it matter?
You see,
so we all come to, you all come to the conclusion that the tone of the letter somewhat. But before he says cease and desist, he says, you are kindly requested. Does it matter how it was preceded?
Like I have said, I'm not, as for the lawfulness of what he sought.
Not about lawfulness. Not about lawfulness.
If you speak to the content.
Does it sound disrespectful? Does it sound contemptuous of Parliament? If you don't take away, you are kindly requested to cease and desist.
Like I have said, I'm not in a position to determine whether it is contempt or disdain. That is based on the intention of the person who wrote it and the interpretation of the person who received it. All that I'm saying is that perhaps the president at that level could have called the speaker prior to the letter coming, I think. It would have softened the grounds for the receipt of the letter.
Now let's talk about the speaker's action.
Administrative action.
Now let's talk about the speaker's action.
Yes. Now, that is also very curious. Again, in all the submission by Godwin and Senior Penka, they have not seemed to diverge on what the position of the law is.
Correct.
They have not. They all agree that this is the position of the law. It's the interpretation and the application.
Yet Eduji, curiously, like Afenyo Marking, appears to say, if this person does it, it's okay. If this other person does it, it's not okay. But I'm asking you the question now, from the speaker, on the facts that you have come to know, was the speaker right in what he did?
Okay, so on the 20th of March,
Wednesday,
when the speaker said that I have before me a process, he was referring to only a writ.
correct.
Only a writ. Now, the writ that was filed had in it, I think Zonita Toda filed it, and a relief for interlocutory injunction.
Interesting bit.
And then also a relief for perpetual injunction.
Hold on. Yeah. Go on. I'm talking to Penka,
Okay.
not you.
A relief for interlocutory injunction, also a relief for perpetual injunction. And like I have submitted, I do not think that it is proper to include an interlocutory
That's
relief.
for a judicial determination.
Yes,
I
let me
agree.
finish.
So,
Let's, we can be categorical on the law to the extent we know it as settled. And
No,
that's why the law teacher is here.
But you
Please
see,
allow him.
No, the
Allow
challenge
him.
I have
You know.
where,
I hear a lot of the debate
a
in the
claim
public
is being made,
where
for instance,
even media moderators will say, "Oh, if you put 10 lawyers, they will all disagree," which is a lie. Okay, there is settled law that we must educate our populace to know that this is settled law, and not say because Eduji says it's this way, this one says it's this way. There is no settled position. There's a settled position. So please go on.
So you cannot include an interlocutory relief in a writ.
Right.
Now, as at the 20th of March,
Right.
when the speaker said that he has before him a motion or an interlocutory injunction, we all know that there was no such application pending. And so if on the 20th of March, the speaker says that based on an interlocutory process or a process before the court, I'm suspending parliamentary proceedings, with all due respect, I do not think he had any legal basis to say that on the 20th of March. If he had said that on the 21st of March.
So he was peddling falsehood.
Maybe, you see, like when you say that, it means there's an intention. Perhaps.
No, but he said he has an injunction motion. He was playing
which we all know it is not.
Because there had not been an injunction motion.
Obvious untruth.
So it was not so. Now, if he had made that statement on the 21st and said, because there is an injunction application, I will suspend and let Supreme Court decide, I would have agreed with him. But on the 20th, there was no such thing. And
why will you agree with him?
Because
when the suit is challenging a category of ministers who are not the subject, who are not the subject of the vetting.
Again, Samson, the reason why I am slow to go into that is that then you are going into the merits or the
We are not going into the merits.
Because
let's be plain, we are not going into the merits. Let's not hide around it. We are not going into the merit. There are two categories of ministers. Ones whose appointments were revoked and reassigned. We know it's a question of nomenclature, but that nomenclature revoke can bring trouble. That's why we leave that to the Supreme Court to determine whether once you have said revoked, we should treat it as de minimis, that it doesn't really matter, it's only form over substance, or that in fact, on the basis of J.H. Mensah versus the Attorney General, once you have said revoked, you must bring them for prior approval. These class of appointments have not been submitted to Parliament for approval.
And what
then the Speaker says, because of this injunctive process, we also want to respect the courts.
When at that time, the people that were
as of now,
before,
even as of now.
the people that were
that have
before
been
them were not
vetted.
the subject matter of the Supreme Court suit.
Exactly.
Then that becomes a different discussion. Because then if at the time that the speaker was saying that the people that were the subject matter of the Supreme Court action were not the parliamentary proceedings, then did he have a basis to say he's suspending it? But I was listening to Mr. Markin, and there was something interesting that came out. I have heard, because I've not been a member of parliament before, that in most of the time, before a speaker makes such decisions, he discusses it with the leaders of the different sides before he comes out. Perhaps, and Mr. Markin is saying that did not happen in this instance. That was curious for me as well. Because perhaps if those consultations were made, his attention would have been drawn. But you see, members of the minority, and I've heard Mr. Haruna speak to it, seems to agree with that position. So is it that there's a fundamental misconception of the people that were the subject matter of the suit, or like Mr. Tenka keeps saying, it was pure mischief, just to derail the process?
All right. Very, very interesting. So there are a few things we have established for you here this morning. And just by way of a very brief recap before we go into the other politics of the discussion, we take a break and return to the politics of the discussion. When a court process called motion or application for injunction, interlocutory injunction, interim injunction, is served on you and you are a party to the suit, you are not supposed to do the things that application is seeking the court to decide. You are holding a piece of bread. The other party says, that bread belongs to me. The court should stop you from eating the bread. You are not supposed to eat the bread before you appear before court. If you do so, you have done the job of the court and you are in contempt of court. Number two, that in fact there were 2 injunction applications pending. One, call it a repeat, by Amanda Odoy, who had filed one earlier in 2023, which was dismissed in July 2023. She had filed another one on the 8th of March 2024. Richie Sky had also filed one on the 8th of March 2024 after he had filed the original process, as in the writ, on the 7th of March. In Richie Sky's request to the court, he says Parliament should be stopped and the Speaker is one of the parties to the suit. The Attorney General is one of the parties to the suit. Richie Sky says, stop the Speaker or Parliament from taking the bill to the President. The argument here is that the Attorney General has been served. It says, Mr. President, don't accept it. If you accept it, you could actually also be in contempt and you are not doing the right thing. So those, for now, are settled. And another important thing is that Roxanne Nelson Dafiamapo's suit has nothing to do with the MPs who have been vetted. He is seeking to compel the president to bring the MPs or the ministers he has reassigned to be brought to Parliament to be vetted. So if in fact they were being brought to Parliament to be vetted, Roxanne would not have sued. He says, you revoke the appointment and you reassign them. If you want them to become ministers, bring them to Parliament. Those people are not in Parliament. So what did the Speaker speak to when he said, we cannot continue the approval of the ministers, nominees whose appointments had not been revoked or who are just freshly appointed or nominated? We'll take a quick break. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. It's been heated and it will continue to be so, it appears. My guests in the studio are Joseph Dindiok Pemka, who is former Deputy Attorney General and former Deputy Minister for Justice, and former MP Timpani. Godwin Eduji Kujo Tameklo is Director Legal, Directorate of the National Democratic Congress, and Bobby Banson is a lawyer, law teacher, and author of legal text. He has a very fresh book that has just been released, and we all will enjoy it, about commercial arbitration. I'll be hosting him one of these days on my law show to go deeper into that book. Now, we will ask a few questions, but I have some of your messages here too. And it appears that the Speaker and the President, that is the Attorney General, are likely to face a series of suits in the coming days, including a suit for orders to compel Parliament to transmit the bill to the President, and also orders, seeking orders by way of mandamus to compel the President to accept the bill when it is submitted to him, and for him to perform his Article 106 obligations to assent or decline assent and indicate why. Then there may be a suit also asking the Supreme Court to interpret Article 106 and hold that the President cannot prevent presentation of the bill, and that the letter by his Executive Secretary Nana Beduetu Asante violates Article 106, and an order for that letter to be withdrawn. Some of your views here. This one from Emily Quago says, in simple terms, separation of powers is at work, curbing the power of one organ of government that is always in an arbitrary position. Kudos to Gbagwin. Dom Senea says the Speaker is absolutely spot on with the decision he took, unlike the President, which wasn't well thought through. Okay, so maybe you send this ahead, or you still send it regardless of all the education you have had. Smooth Low says, at my age, I have seen differing leaderships. I have never seen any president run down our democracy like our current president. Della Manuel, in summary, a good turn deserves another. Kwesi Citizen says, I think it's a matter of rule of law. Both of them are waiting for the outcome of the court. Amable Benson says the Speaker is following the precedent by the precedent. By the president. Now, during our break, something briefly came up, and I want my guests to express their view on it quickly so we move on. So I don't know if it's putting you in a difficult situation if I throw that question to you. So, Bobby, how do you think this can be resolved? The president, in the situation he finds himself, what should he do now? And the Speaker and Parliament, in the situation they find themselves, what should they do?
I think there are two ways of looking at it. The legal processes.
Right.
And, should I say, socio-political processes. I would want to, in terms of the legal processes, as far as the Supreme Court processes are pending, until they are withdrawn by those who filed them, I do not know how much the Speaker and the President can do in respect of that.
Okay.
But the socio-political processes, I think that we find ourselves in a situation where if we are not careful,
you meant to say you do not know what the President can do, not the Speaker, because you have underscored that the Speaker had no basis for what he did.
Yes. So in terms of the President, I agree with the position that they have taken because of the specific relief in the interlocutory application.
Okay.
But with the socio-political and governance issues, we do not want to have ourselves in a situation where we should think for future generations or for as president that the three arms of government, particularly the executive and the legislature, when they are not from the same political tradition, will not necessarily collaborate. Because some of us were happy when you had a Speaker of Parliament from a different political tradition and a president from a different political tradition to test our democracy.
We were and are, or we are not?
Well, from what is happening, it seems as if, okay, is it for the sake of expediency? Should we make sure they are all from the political tradition so that there would be some form of collaboration.
So they will rubber stamp all the nonsense we sometimes are.
Well, that is what I'm saying, that if we are not careful to resolve it, that may be the inclination that, listen, we have to present.
It's one of the solutions now, quick solution. Is it for the court to immediately, on its own motion, ask all the parties to come to court and for the applications to be determined?
Oh, yes. The Supreme Court has that jurisdiction. In fact, every court has that jurisdiction to say that due to the expediency of the case, we'll set 5 days, Monday to Friday, we'll finish this case. They are doing it in one of the criminal matters. So they can do it in this one. With Monday to Friday, we will solve it.
There are only applications pending.
Yes, but the rate itself, they can fast track it and, what's the case? The timelines when you have to abridge the timelines in the rules of court and have it disposed of before.
So do you suspect if they did so?
Yes. And then they sit, and do it even.
A sole judge make a determination, and the matter.
So they can do that.
We are not close to vacation, so let's not even talk about vacation.
No.
I know why you're saying that.
They will go for the 2 weeks in the Easter break.
Right.
They can do that.
Right.
But that will not, I think, resolve the socio-political question.
Do you think that the Supreme Court or the court may not be minded to quickly bring all these things quickly and get it done with because of public perception that you want to do someone a favor or the sort?
You know, we have been in this country where the NDC had complained that in some processes filed.
Very recently.
Yes. The Chief Justice exercised administrative authority and asked that it be done expeditiously. Whilst in some other processes, they were allowed to go. And so if you adopt or if you look at that approach, some of the questions that may be asked is, how will that discretion be exercised and in what circumstances? Because almost every suit in this nature has some form of agency that comes according to the person who filed it. And so that leaves the room. Now I'm thinking, and again, I bring it back to it, I'm more interested in the socio-political aspect, governance aspect. Is it a case where we can have, for example, the Council of State invite the Speaker of Parliament, the President, because something obviously, there seems to be some gap in communication. It is very obvious.
Therefore.
Yes, because if you have the Speaker of Parliament say things like, I will not sit and under my watch, democracy will be undermined. That obviously is directed as the president. And so if you suggest that the president of the republic is seeking to undermine democracy, there's a problem. If you have the letters that the speaker...
The president has also made a comment that equally are quite, somehow about the speaker.
Yes, so if you make those comments between the two of them, it will not augur well. I think that the Council of State may sit.
The last and a minute. Is there a solution in the Dafiamapo suits? In the J.H. Mensah case, when he sued and said, the president must submit the people to us to vet. If he doesn't do that, he cannot have them to become ministers. Whilst the case was going on, they did the right thing. In this case, it is the use of the word revoked, which if it was missing, simply saying reassigned would have ended all the issue. Can they correct it now?
I think they can. They should, for lack of a better word, eat their humble pie, acknowledge the error they did in the letter that was written to the parliament, withdraw it, and use the appropriate legal language. That would avoid some of these confusion. And once that is done, there's no action. I do not see how a court can injunct the executive from withdrawing and bringing the... I do not... It cannot work.
It becomes moot?
It becomes moot. So once
you share the same view, Edwige?
It will correct the confusion.
So again, because you referenced the J.H. Mensah decision, remember that even when subsequently President Rawlings submitted the names of Kwame Pepra and others, the Supreme Court came to the conclusion that yes, it had become moot, but because this matter can happen again, we'll proceed to make definitive, constitutional pronouncement about it. But you see something, just a quick one. when I listened to my learned friend, Bobby, he made the point that Speaker had no legal basis in the suspension. I want to beg to differ.
On the 20th of March?
Yes, I beg to differ. Because you see, the Dafiamakpo rate is dated 18th March. Now, Relief 9 of the Dafiamakpo rate reads, and I just want to read, an order of interlocutory injunction restraining the Speaker of Parliament, the first defendant herein, from proceeding with the vetting and approval of the names of the nominees of the President submitted.
No.
That was the relief. So it is on this basis that the Speaker granted his action. There was a substantive matter, and it was on the 18th.
So he's saying that. Saying that.
No, but you see,
I want us to clarify to our audience.
Just 30 seconds. Wait. But you see, Bobby had made a point here that in his mind, and the received learning, is that you cannot endorse on the face of a rate an interlocutory application. Yeah. I am saying that the proprietiness or otherwise of that relief
must be determined.
Yes. So as at that time, the Speaker was not in error if he based his action on that. So at this point,
there was no injunction, number one.
But there was an interlocutory, an application.
Not application.
No, it wasn't an application.
No, hold on. What I'm trying to say,
it was not an application.
An order for interlocutory injunction.
So the mere filing of a writ does not operate as an injunction in the form of an application.
No, you see,
that is what I'm saying.
This suggestion
that if you go beyond that, the mere filing of a writ, the mere filing of a writ, no matter the relief you put on it, no matter the relief you put on it,
no, hold on,
it doesn't operate as an injunction.
So let me
the mere filing of a writ.
You see, our president on the 4th of March met the diplomatic community, correct? When he met the diplomat, he said he's unable to sign on to the law passed by Parliament on 28th of February on the basis that there were 2 pending suits. Are you reading? As at that time. Were there any injunction either by Amanda or Richard Sky? No. In fact, on the 4th, Richard Sky had not even issued his rates. So what are you talking about?
No, wait.
It is either the president is ignorant of the position that you are making. This was what the president said to the diplomat.
It doesn't matter who made that mistake, whether the president or the speaker.
So that is why
that is what I think the law is.
Let's clarify the issue.
Thank you.
That this is the reasoning out there.
Clarity.
Yes.
Dafiamakpo is saying that there's 2 classes of ministers.
Perfect.
One group of them, you have not brought them to Parliament for vetting. I want the court to compel you to bring them before Parliament. Nonetheless, until that has been done, even those that I am not fighting against, they too, the court should stop their vetting. This is what this is.
Yes. And in fact, if you read...
How does that sound to you?
No, hold on. If you read the Relief 9, and I do not want to sit in judgment of the processes filed by a learned friend here. What I'm just saying is that if you read Relief 9, he says that even those whose names are going through the vetting, court restrain them until the president perform the task that you are talking about. So the Relief 9 is even more broader in scope. What he did.
The interlocutory one.
Yes.
The interlocutory one cannot be broader.
No, but what I'm saying is that it is either he anticipated your position, and that is why he formulated
the interlocutory one.
The question to you was just a minute. We actually have run out of time.
So the suggestion that the speaker did not have any legal basis, I disagree.
I was saying, thanks for your disagreement.
Yes.
I was saying that the mootness argument, do you share in it?
No,
that if they change the wording of the communication from revoke, they take away revoke, withdraw the earlier one and bring a new one, this suit becomes moot.
In fact, absolutely. There are many options open up to the presidency. In fact, it is on the basis of the letter that this action is founded on. As to whether the presidency can take away the arrogance and admit that as a human institution, we are fallible. The wording, because that was
all right,
clear.
thank you. Let's not
once you use the word revoke, everything becomes anew.
You have to start afresh.
And so if that reasoning is permissible within the presidency, why not? But you see, something, just 30
Thank you.
seconds. On the issue of cooperation, I strongly believe that this is the most cooperative speaker I have seen. The most cooperative. It is the body language of the presidency, the executive. That is why. Look, I've heard people in NDC say, Mr. Speaker, this is not why we fought on the midnight for you. We wanted a stronger distance. That conversation exists.
Yeah.
You understand? So
what
he's
do you
been
also
very
think?
cooperative and allow government business.
Thank you,
it is the language of
Edudzi,
Akufo-Addo that is becoming.
What do you think about this proposal, which can end one part of all of this tussle, that the government, the presidency, will simply write one small letter to Parliament and say, this communication we sent to you earlier, we are withdrawing it. And then write a new one and not use the word revoked. Ends the matter.
Yeah, I mean, I have stated time and again that where you come to a state where you have to take a certain step to rectify everything and move on, you do it. I mean, it doesn't destroy anything to withdraw it. It doesn't at all. In fact, it will end all the suits that are being inundated in the courts and etc.
The suit in respect of only the
courts work easier.
Very, very easy. You know, it's possible to get it withdrawn. But you see,
would you also propose that the courts should abridge the time quickly?
That one I agree with it. I agree with it. Just give it priority attention and then get it done.
No,
but quickly, you see, let's be very honest in looking at some of the issues. You've stated your position on the matter, but you see, my brother, when the speaker said there was an injunction application, let's all admit there was none.
No, he said a rate. He said a process had been served.
Hold on.
On the 8th, no, hold on. The speaker went. It's a whole statement.
Can I look like this morning? No, can I look like this morning? When you are speaking, I say nothing. When I'm speaking,
no, but you say,
use the word injunction application.
No, you see, you are creating the impression that there's.
He said there was an injunction application.
Can we look for that specific pronouncement and play?
And there was none. At the time he was making the pronouncement.
So can I read the entire?
No, sorry, I'm sorry.
Can I read the entire?
Let's hear you. Go ahead.
To help us.
Go ahead.
And I'm saying that smoggling in a relief for interlocutory injunction among the
how can you say it was small?
Oh, that is my opinion.
Edudzi, please.
It's not fair.
I don't like that.
Please,
It's my
ignore him and speak. Go ahead.
And then bring it in there so that it will serve as an injunction. It's completely untenable. So what I'm saying very simply is that at the time Mr. Speaker made those conclusive determinations and said that there was an application for interlocutory injunction, none existed. We have to all admit that. And then we can set off from there. And so subsequently, the application for interlocutory injunction was filed. But Samson, just to conclude on this matter,
wait. Here is the Speaker's statement. The last two paragraphs. Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts.
Process.
Relax.
Good.
Titled Roxanne Nelson Echeke Dafiamapo versus the Speaker of Parliament and Attorney General. Suit number J1/12/2024, which process was served on the 19th of March 2022, and an injunction motion on notice. Relax.
Yes.
An injunction motion on notice seeking to restrain the Speaker from proceeding with the vetting and approval of the names. So,
where was that injunction?
And on this account, there was none.
There was none.
I am saying that the Speaker
admitted there was none.
No. The Speaker made a point clear that two processes.
No.
It's not in doubt that as at the 18th,
okay,
there was
so
a
we'll not continue with that. We'll not continue.
You don't want to admit this?
What is it to admit?
I'm not reading the
I am
Speaker's
saying
statement.
that the Speaker did not just make the statement in vacuum.
Okay, so
he had been served with a writ.
thank you.
Well, there was no application.
The
for
Speaker
injunction.
said he had been served with a injunction motion on notice. There was none.
There was none.
We must not mislead our audience.
That's all about
There
it.
was a writ on the Speaker.
There was a writ, but
on
not
the
a motion
19th.
for injunction.
Are you denying
there was
that?
no motion
Are
for
you
injunction.
denying that?
That is not denied.
Good. So let's proceed.
You know, again, we were looking at the legal education that we are offering our audience. And the lecturer even indicated it very clearly. You know, you go and bring in an injunctive relief in a substantive relief in an application, in a writ before the Supreme Court. You know quite clearly that we're not making any definite pronouncement, but you know the position of the law on that. And so to bring that and use that as a motion, equating it to a motion is also wrong in law. And you cannot equate the two at all. So what Mr. Speaker said at that particular time, I would not say was false. It was an untruth. That he was making.
That's
about the motion.
when your president spoke to the diplomat, Was it peddling
Eduji,
falsely?
stop.
No, but it's not fair. The speaker is not here
stop.
to ask
Eduji,
for
stop what you're doing.
Don't create an
It's so
impression that he
unfair to
set
the
out
show.
to mislead
It's
people.
so unfair to our viewers
Was
and
it fair
listeners. Stop.
to say that the speaker set out to mislead?
Okay.
It's
I was
not
going
fair.
to ask you this question. That will be my very final question on this. I have sat in the Supreme Court where there is a substantive process, writ, without a motion for injunction. And the court cautioned the Electoral Commission not to take any step until the matter was dealt with. There was no injunction application.
On the district assembly election.
Again, yes. Again, if you look at the Dufour case that we have referred to over and again, at page 10, the court said the judicial power of Ghana by Article 1253 of the Constitution has been vested in the judiciary. This power cannot be fettered by any person, agency, or organ, including the President and Parliament. Any conduct that contravenes this provision is clearly unconstitutional and as such null and void. When a court is seized with jurisdiction to hear a matter, nothing should be done to usurp the judicial power that has been vested in the court by the Constitution of Ghana. In effect, the state of affairs before the court was seized with the matter must be preserved until the court delivers its judgment. This is so because whether or not the court has granted an order to preserve the status quo or not, a party to the proceedings will be in contempt if he engages in an act subsequent to the filing of the case, which will have the effect of interfering with the fair trial of the case or undermine the administration of justice. The conduct must be one which has the effect of prejudicing or prejudging or prejudicing the case, the case, even before judgment is given. Do you think you need an interlocutory injunction in a suit in the Supreme Court before you can hold back and say, I won't do anything?
Yeah, there are certain situations you may need it. There are certain situations you may not need it. And then your suit itself will address it. You see...
They didn't qualify this, so
yes.
It was general.
Look, hold it. But then several applications for interlocutory injunctions have come before them, and they've also made pronouncements.
Yes.
So, I mean, you take this one in isolation...
The ratio must be in the context of those facts.
In the context.
Because, sorry, if I may.
No.
Like we said, injunction is an equitable remedy. Yeah. So they will be guided whether they are alternative remedies.
Okay.
Now, in this country, there was a famous case in the 70s where the state wanted to deport someone. Is it Dombo? No, I've forgotten.
Ladan.
I've forgotten the
Producer.
No, this was not a Ghanaian.
No, Ladan
okay.
was the interior
Nigerian.
Nigerian. Wanted to
Ladan now in Nigeria.
Yes,
okay.
yes.
And then a writ was filed, an originating motion.
Yeah.
And in that court process, they deported the person.
Yeah, they were
so
convicted,
that one you
contempt.
look at, okay, if at the end of the case, and they find that you did not have the legal basis, you have deported the person, they cannot order that bring the person back. Because such an order, if made, how are they going to enforce it by the court?
All right.
And so it must be situated.
There was just this last bit I wanted to tell you before my brother came in.
Thank you.
The last bit I wanted to come in was that, you see, I have said it, and I mean, we are not attempting to pass any judgment on what
30 seconds.
has
30 seconds.
done. But I have said it that what he's seeking to do hasn't happened. He's seeking to say that those people should be brought to Parliament and vetted. They have not been brought. He's seeking to injunct Parliament from proceeding with the approval of people who are not affected by the action he's seeking to cure. So the mischief he's seeking to cure has actually not been committed in Parliament.
Okay.
And so what he's seeking to stop...
Thank you very much. And I have... sorry. Again, there are many of your messages. We are taking a break here. You did that. We are taking a break here. And when we return, we'll be going to the ECG where PURC is asking a number of questions. But if there's one thing that this anti-LGBTQ bill has revealed to me, and perhaps to you, it is that some of our leaders can tell untruths. The president said there was a writ. At the time, there was no writ by Richard Sky. He said it was the next day before the writ was filed. The Speaker said there is a motion for injunction. There was none until the next day. We'll be right back. Welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. And as we go to check the ECG, I promise you I'll share a few more of your messages before we move on. And this one says that away from the legal technicality, that's from Al-Haj Suleiman. Away from the legal technicalities, to be honest, I see clear antics on the part of the president. Consistency is not on the part of the president, and that clearly raises questions about his true intentions. For me, the president simply doesn't want to sign the bill and is thus seeking cover from the technicalities of the law. And okay, thanks for that. That's for how you view it. This is from Irabna Opoku Bediako, and she says that clearly the NDC MPP do not respect Ghanaians. You see why I say we shouldn't call them honorables. They are not leading the way, and this is unhealthy for a country that is talking about moral standards. What law can we invoke to ensure that they desist from telling lies? A law to invoke to get people to desist from telling lies. Okay. Interesting there from you also. All right, let's stop here. Now, let's get to the Electricity Company of Ghana, which is presently in the eye of the storm because there has been a work of some audit or some validation process done by PricewaterhouseCoopers, of course, under the auspices of the PURC, and I think it's the ministry also. And the findings are not pleasing at all. They don't seem to have seen anything good with the Electricity Company of Ghana Limited, at a point that many have come to conclude that they are doing quite a good job. Well, interesting. Some of the observations they have made is that there's a decline in the quality of service delivery, including increasing power outages across ECG service areas from January 1, 2024 to date. There's increase in complaints related to billing and estimated consumption of ECG postpaid customers, charging of unapproved service connection fees by ECG among other issues. And the report, charging of unapproved fees, approved service connection fees by ECG, and the PURC is seeking that the ECG or has actually issued an order to compel to them to comply with the cash waterfall mechanism. What is it? You get to know it. And pay all tariff revenues as prescribed and allocated under that mechanism to secure the financial integrity of the sector. They are also ordered to submit copies of government directives to ECG for the purchase of fuel for power generation from August 2023 to date, details of all bank accounts and investment accounts currently operated by ECG, a lot of other things. So let me just begin with my guests so we'll get to go into some of the details therein. And Pemka remains with us here in the studio. Edward Abambiri Bawa is MP for Bongo and member, Mines and Energy Committee of Parliament. We have Alhaji Jabaru Abubakar, Director, Regional Operations and Consumer Services of the PURC. And Ben Boachi, who was with us last week, returns. He's Executive Director of ACEP, the Africa Center for Energy Policy. Gentlemen, thank you very much for making time to join us. So let's begin with attempting to understand what is going on. And has there been a loss of 1.9 billion cedis, as the report suggests or states? Let's begin with Ben Boache. Ben, help us understand what is going on with the ECG in respect of this validation process.
Yeah, I think something the country agreed, whether you liked it or not. It was a decision of cabinet that we initiate a process where whatever revenue that comes in. First of all, what triggered the cash waterfall mechanism was the fact that not much revenue was being collected to be able to pay everybody in the value chain. So government decided that they will set up, that mechanism where whatever comes in will be distributed proportionally for every player in the sector to at least get some resources to operate with or to run with. And it was agreed. And I think it's been running for some time now until it started, seeing significant cracks in the process where ECG decided not to put all the money into the cash waterfall mechanism, but appropriated more of the revenue to itself than what was described by the cash waterfall mechanism. So a process to revisit that conversation and streamline things really is what has, brought us here, because then PURC and the government agree that let's go into ECG to see what is actually happening. How are they utilizing the money? Where are the collections going? And prior to that, a directive, a clear instruction had been given that, ECG opens a single operating account where all the money would be put in so that the distribution is much more transparent and accountability therefore improved. So they wanted an auditor to go in to see if that was actually what is happening. And the revelation is staggering to see that from a single account proposition by cabinet, and as PURC keeps indicating, where the president himself was involved, that is what ought to happen. ECG was operating about 30 accounts with about 16 banks, from single to 16, not 3, not 4, 16 banks running several accounts. So that is what PricewaterhouseCoopers have been struggling to get enough details to come to a solid conclusion on how much actually ECG collects. What remains outstanding reading that report, and much critical also, is that we do not know. We don't know how much ECG actually collects, because they have not made available all their accounts for the auditor to ascertain how much they actually collect. So on the supposed single accounts, they don't put all the money in, and then they have scattered accounts that they will not disclose its content for you to be able to track how much they actually collect. And over time, we are seeing a widening under recovery. What that simply means is that how much they are supposed to collect, versus their bills, increasingly not matching, and therefore the state is consistently called upon to intervene or to pay. They are the owners of the utility company. So this is really what has happened, and what PURC and PwC are asking is for more data so that they can be more conclusive on what the revenue outlook looks like and what a decision can be taken based on what is being collected. So it's possible that what we call even inefficiency is just a lack of accountability. If you do not know how much is collected, and we classify a lot of things as inefficiency, it could just be somebody deciding not to account for the money that has come in. And getting to the bottom of that becomes increasingly important for the sustainability of the economy and also the power sector specifically.
So in reading the report, I also acknowledge that the report is sort of titled final drafts. So you are saying that you expect that something else will happen to change the adverse observations that they have made and the recommendations that have also been made in the report?
I think it's not a final report. They're looking to get all the accounts of ECG to be able to ascertain how much actually came in. Because, for example, if you have a single account where you're supposed to pay all the money through, and it is found that you paid, more than 600 million out of other accounts, how much millions do you have still in those accounts? The auditors are interested in knowing. And why would anybody stonewall access to those accounts? Are very intriguing for all of us to see how that comes to light, for us to appreciate it more and more. But at this point, we will say that we need that data to be able to clearly define the challenges of the power sector and why liquidity has become a major challenge at this point.
What's your understanding? This and the media reports, some of which said billions have been lost. What's your understanding of that?
I think at this point they are reporting discrepancies.
Because they refer to them in the report as a difference.
Yes.
So that's something that's not accounted for.
They still want to give ECG the opportunity to clarify and provide a backing documentation on those specifics. And that is what is outstanding for the report to be concluded, from my understanding and my reading.
Right. But in that case, why at all should this become a public debate when it is not concluded? And the PURC is this unhappy? Why?
Yeah, I think I saw PURC's statement and it really struck me. And my understanding and what I perceived it was that PURC is perhaps trying to rediscover itself and be able to be the regulator that it's supposed to be. Because their primary function, really, is to protect the consumer and also the businesses, the commercial interests of the businesses. All right, and in doing so, you approve a tariff that should ensure that the distributor does not undermine the generator, because without generation, there will be no power. They do not undermine the transmitter. And therefore, every interest is accounted for. And most importantly, the consumer's interest is protected. And regulations ensures that the consumer is not abused. And consistently, we have seen the consumer abused. And PURC has folded its arms and watching ECG abuse consumers. All right, so to see this directive, even though they could have done more, I think it's in the right direction for us to now see how we track, the delivery of the actions that has been outlined in that report. And I think also what I also picked is that this signals clearly and confirms all the speculations about confusion in the board of PURC itself, where some commissioners have even started resigning and could have been an exodus of many because of stonewalling and political interference with the operations of the commission. And therefore, the resolve was then that let all of us come together and sign a directive to make sure that ECG complies. And that's why you see all the commissioners signing a statement that ordinarily could have been signed by either the executive secretary or anybody appointed to do so. So it's really interesting to see how these things are panning out, but I hope that we can track the directives and get the results to protect the interests of the consumer.
Having followed the ECG, process so far, they want to call it transformation process. I don't know, you agree with that. Do you find something, concerning about a report that doesn't seem to have anything positive to say about the ECG?
From where I sit, I'm not surprised. So you have a power system that is doing less than 50% of revenue requirement. That clearly suggests that something is wrong. And we need to have answers and solutions to that problem. And more so when those under recoveries come at our labs. We have to pay. The public has to pay for any under recovery or inefficiency that is occasioned by ECG or any utility in that space. And the state is paying. I mean, if you look at the ESRP report, between 2019 and 2023, we have paid over $5.7 billion, right, from the state and from us, through ESLA and other, levies. We keep paying, and there is no end in sight, right? So we knew that these things were happening, and PRC didn't go into it, perhaps in a timely fashion, to ensure that they could curtail it. They restricted themselves to just issuing tariffs, whilst the sector degenerated. And also the players, ECG was abusing everybody without accounting for the revenues that are supposed to come in to ensure that the state or the budget is not called upon to actually address these inefficiencies.
Does it make any difference to you when you hear that, and we have confirmed with multiple sources that show us these facts, to which we have no contrary fact to, that there was no single collection account in July, and that ECG had multiple accounts? They started paying in August, and they didn't start paying in July. Not in July. July payments were made by the Ministry of Finance. Effectively, the single collection account started in August. In July, they were asked, that's the ECG, was asked to make payments to Car Power, which effectively meant that the Ministry of Finance had to start the process. And since ECG took over, there has been no default. ECG from August to December has paid the IPPs to the tune of $305 million, and the SOEs in excess of 1.6 billion Ghana cedis. It has spent 236 million on fuel for the power plants, which the cash water mechanism is failing to recognize because it was meant for disbursement to the SOEs. And ECG has been awaiting a refund from the Ministry of Finance for onward disbursement to the SOEs. ECG has not done anything wrong in this direction. How does this change your perspective of what you have read?
No, it's whatever you read is immaterial. I mean, the fundamental point was that pay everything into an account. And the SOEs, the IPPs, they were all involved in making sure that we had that structure so that there is a formula that benefits them. It benefits the IPPs, it benefits the SOEs. So that all of them gets a portion of the true number that is collected. So ECG's function and duty is not to have the discretion to decide who gets paid and who gets paid what. Their mandate under that directive was to pay every PESWA into a single account.
Which they did.
And a formula is applied.
Which they did, correct?
They didn't do it. They have not done it. And that is the problem. So you pay that into the single account.
There has not been the single account to which payment is made?
And then that is one. And then also proportionally distributed based on the formula that has been agreed or approved by PURC.
Okay.
Right? And that's been the major contention. And the reason why PricewaterhouseCoopers had to go in to do the audit. They were not complying with the cash water for directive that put every money into the account. And that was also to check discretion on who you decide to pay. There is fairness in the formula that has been produced to make sure that everybody knows how much they are getting. If you check the payments of ECG today, you will see massive discrepancy, even at the IPP level, who gets what. So then it becomes who ECG wants or who they likes. They pay more.
Let me bring on Alhaji Jabaru. Abubakar, Director, Regional Operations and Consumer Services, the PURC. Thanks for joining us.
Thank you very much, and good morning to you and the viewers and listeners.
Right. So we have a report that appears to be incomplete. It's not final. Why should that be a basis for this, impasse, so to speak?
Thank you very much. First of all, let me say that the report that maybe the media has taken on is posted on our website, and it is not one of the reasons why we issued the order, though we mentioned that at least.
What a coincidence.
ECG, oh no, it was hosted there, but because of the order, I think a lot of people showed interest in our website and they were able to see it. It's been hosted there for over 2 months ago. So the PURC is enhancing transparency in terms of its regulatory work, because one weapon or tool as a regulator that you do is to be transparent with whatever that you do. And I think Ben has mentioned, though I disagree with him on some few issues, the PURC acted at the right time, because the regulator mostly wouldn't come to public. All the communications that we do largely is on our website, so that people will know what is happening. I agree with him to the large extent, protecting the interests of the consumer and the service provider, that is the utilities. And the value chain, we have generator, we have transmitter, then we have the distributor. Unfortunately, the distributor takes the money in the value chain because he deals with the customers. So because he takes the money, we realized that there was no that continuous flow of revenue to all the others. And you know that people make their planning and projections based on whatever income comes to them. And some of them would have also made some commitment against their cash flow or the inflows that they are going to get. So in the wisdom of the sector, I think government had a directive that we should have this cash waterfall to accommodate that, so that when whatever comes in is equitably distributed, so that everybody will be able to plan, irrespective of how little it is. So that was the basis for this cash waterfall. So at a point, there were some challenges and complaints from various stakeholders. So it was resolved by the stakeholders within the industry that why don't we have an auditor to look at, first of all, the guidelines for the CW, then also to know where the current position is and where to move from. So that is how the PwC came into the picture. So the commission was tasked to lead the team to get consultant. And it wasn't only ECG that was audited, even NETCO was audited by Deloitte, which we also did. So I think if you read the report, you will see that the auditors even expressed challenge of the data that they couldn't get to.
And it's one of the recommendations eventually.
So that is one of the reasons why it is not concluded. So, but if you look at the other one, obviously they had concluded their work because there was some supply of data and they could work within the specified time. So that is just to, but what I would want to let us know is that if you go to the PURC Act, the functions, if you look at 3C, D, and E, is very, very important for people to know. And I'm happy that at least you have panel members who understand the industry that much. And in protecting the interests of the utilities, we have come up with rates, which is within the revenue requirement. They brought us their operation costs. They brought us all the needed revenue that we need, and it was approved. If you go through the distribution company's operational expenditure, which line are you going to charge fuel to? And like Ben has mentioned, so there are every line of expenditure that lines that we have within approval processes. So you have a revenue that is up for ECG. Where are you going to charge it? And misapplication of resources also distort whatever the financial planning of everybody. And these are the things that we want. So if you put whatever you have collected into the chain, Greco gets what they want, the IPPs get what they are. It is immediately you do that, you are distorting the thing, and somebody will be at a disadvantage or advantage. What I will want us to look at to know is that this is a serious matter. And as a regulator, before you see us issue an order, that means that we would have written to require this information, which has not come within the required period that we have requested it. I have said on several platforms that the regulator, we don't write open letters. We write letters with terminal times and dates. We want this information depending on the agency of it by this so and so date. So if you don't supply us the information, then looking at the agency of it, we have the option to move. This is not the first time we have issued orders, just that it has coincided with some of the challenges that Ghanaians are facing regarding it. It wouldn't have come up if we had all the data so that we'll be able to do the analysis and come out with our conclusions, find a remedy or solutions to whatever that we are having. That is why you would have seen that maybe we have moved to the level of an order. But if not, the PURC always have corresponded with the utilities. And we've been very, very proactive when it comes to monitoring the system. We know the challenges that have been there. We have gathered data, we have done analysis. We are just left with the last lap of that data. And that is why if it was not forthcoming, we have to now issue an order. If you say you have 630 transformers to which is not, which are overloaded, to which the regulator is not aware, how will the regulator be able to do analysis and do planning for it? And if you even have to replace them, is it in your, as a distribution company, was it part of the revenue requirement that was approved for the tariff control period? These are the relevant questions as a regulator we will do and we will ask when we are around the table. And that is why we require that we should be supplied with that information. The dual codes, we will do our verification. We have very capable men and women, and we have capable logistics and instruments to be able to check independently. And that is why we have asked for all these things. So we don't do our regulation, maybe yes, civil society, they do a lot of advocacy, but as a regulator, we are very confidential in whatever we do. So we have discussions with them. But if we don't get the information as required, obviously we move to the next level. And that is what we did by having the order. And the order is to make sure that please go by the cash waterfall. Please provide us the details when it comes to the overloaded transformers you have mentioned. You've also indicated at various platforms as ECG that you were asked to buy for. Give us the invoices. Give us all the contracts that governs the purchases of the fuel. These are simple matters that we have asked.
Okay.
Nothing to do indifference or impasse. We are a regulator, and Bernard has mentioned the act gives us the right to be able to.
And do you have any indication of a resolution as quickly as possible or any time?
Oh, it's not about resolution. They have to respond to it, and we'll do our analysis because the order we have given is not conclusive. Okay. We are yet to interrogate whatever facts that comes to us. We are not just demanding the data for demanding it. We are demanding it to go to an end, and we are sure and hoping that this matters will come.
Thank you.
To an end.
Hold on for me, and Edward, thanks for joining us. So let's understand your appreciation of what is going on with the ECG as far as the report and the orders from the PURC are concerned.
First and foremost, Samson, let me just tell you that this is the sheer indiscipline. The sheer indiscipline. And I'll explain to you why I'm making that point. Look, you have a company, and the shareholder says, I want to audit a particular account because that is at the heart of the survival of that sector. Somebody is appointed to audit it. And you, as the person who manages the account, you refuse to make documents available. That's the first aspect. Secondly, you have a situation where the president, who is really the main man for this whole thing, when we talk about the shareholder, tells you, run a single account. Then you refuse. And indeed, not only are you maybe you're running 7 or you are running, actually it's 37 accounts. You're running 37 accounts. You cannot describe this thing anywhere apart from indiscipline. But to come to the main facts, look, Samson, the very reason why ECG is forced to subject itself to the cash waterfall mechanism is because of the fact that simply they cannot account for the power that they buy. And because they cannot account for the power that they buy, the revenues they get cannot even settle all the bills. And so then you have the account, that what they call the cash waterfall mechanism.
Did you mean to say they cannot account for the power they sell or they buy?
They cannot account for, you see, okay, so let me put, that's the tricky question. So they buy power. So they buy it. So let's say they buy 100 Ghana cedis. They cannot account for the 100 Ghana cedis of power that they now onwardly sell. They cannot account for that. And the reason is because if you look at their losses, if you have a loss that is between 32-34%, so I have an issue. If you are buying about 100 Ghana cedis worth of power, you are losing roughly about 34 Ghana cedis. And therefore, you only have 66 that will have to take care of all the players who have contributed in bringing the power, and then you dealing with it. So they cannot account for that. And that is why the cash waterfall mechanism was put in place. Indeed, the very reason why they had to bring PURC in is that even though this is a mechanism that came in from 2017, a lot of the players, particularly the IPP, said that there was no transparency in the way it was being administered. The IPPs were always asking that, look, if I know that, yes, there's a formula that has been dealt with, including even you, ECG, you are part of the formula that has been put. That I know that anytime the money comes, this is the way we are supposed to distribute it. But at first, we'll have to know what is the total amount that is in the pot. It is only when I know the amount that is in the pot, then we can have a situation where we can distribute it fairly. In the first place, the players themselves, whether it is a level A beneficiaries, and that's the IPPs, or the state-owned agencies that fall under the level B, they simply do not know how much falls into the kitty. And the reason why they do not know is because ECG is simply not transparent. And so I'm not surprised that PURC is a system that if you say that part of your money, you use it in fuel procurement, let us see whether you had a directive from the state, and in this case, whether Ministry of Energy or Ministry of Finance, that use part of the receipts that you have gotten in procuring fuel. Let's see your fuel, the fuel contracts that you signed with those who were supposed to supply the fuel. Let's see what about the invoices that were there. Tell us what the quantities were. These are very simple questions that for running a state institution like ECG, you simply should have this data anywhere you go in terms of the offices. So for the ECG not to be able to supply this, it becomes a bit problematic. And that is why some of us have always been worried. If you recall, just before this current exercise that was conducted, and I'm talking of the one that they just did in Germany, disconnected parliament, and they are threatening other hospitals. There was an initial one that was done, the one before this. They have said that their target was that they were supposed to they were trying to collect about 7 billion Ghana cedis. Out of that, when they finished the exercise, they announced 5.7 billion Ghana cedis. As to how that 5.7 billion Ghana cedis was used, nobody knows. In fact, a bit of questions that we gave to ECG when they came to meet us as a company, this is what they said. They said because at that time, one, we had curtailment of gas coming from the west. Two, because of the fact that we was also being scheduled to go under maintenance, they needed to buy liquid fuel for the generating plants, particularly those generating plants that were running dual fuels. You know, there are some of our plants that can run both diesel and light crude oil or gas. And so they bought liquid fuels for that. If that is the case, show us evidence of it. Show us evidence that you actually use these monies to buy what you said you used to buy. So yes.
Why? And they couldn't show the evidence?
They have not. It's part of the reason why PURC is conducting this particular thing through PricewaterhouseCoopers. It is part of the reason why the auditor is auditing these things. Because nobody seems to know where these monies come and where they go. Because look, in January, when you saw the part, at least, even if it's not conclusive, if you have a situation where for the level A, And these are the people who have been threatening us for God knows how long. You will say that for the state-owned agencies, you can find a way of massaging them, even though you are even collapsing them. But for the level A, what do you call it, beneficiaries, that's the IPPs, you were supposed to pay 6 of them. You ended up paying 4, at least from the data that the PwC saw, the 4. And instead of paying somewhere around 308 or maybe I think 316 or thereabout $1 million, you only paid $120 million just to 4 companies. And what Ben Boachi said is true. One of the things they do is that anytime there's a crisis, anytime there's a threat, particularly from the IPPs, they look at individual faces and say, look, I know that this person does X, Y, Z. If I pay this person, you'll be able to give me this amount of power at this particular time. They choose and pick as to who they pay. Meanwhile, these are all people who have invested in their businesses. These are people who must have operational, cost being taken care of. But you do not do it.
You said they had paid the level A entities, the IPPs, only how much instead of 300 plus?
So per the documents that were made available, only 120 out of about 340 or 350 million dollars.
The understanding we have from our multiple checks is that from August to December, they had paid the IPPs to the tune of $305 million US.
Why did you get that your information from? Because if you are stating a source, let me know what the source is.
The source is the ECG.
Samson, this question is to you. Because the point, so that's why would I be taking ECG source? Why would I be taking, if ECG states that this is the amount of money they have paid, let the data be made available for all of us to see. That's just the whole idea. The fact that they say that if I come and tell you, if you, assuming that I have a mortgage on my house, and maybe I still owe an outstanding of about $25,000, and then I get up and say, oh, me, I paid $20,000. Meanwhile, the recipient or whoever is auditing that particular mortgage arrangement says that I'm not paying that amount because the data does not support it. How on earth would you get that? Why would I be taking the figure that you have given? I am looking at the audited figures that have been given, and the very serious part of it, and that's the point that he was making.
Okay.
What's the name, Mr. Abubakar? Look, if you look at some of the state agencies, it's becoming more serious. Greco, for example, they are not being paid. Samson, if you say you are using multiple sources, let me give you other sources to go to. Go to Bui now. You know, usually Bui even invoices in dollars because of the fact that they have to do the repayment for the dam, the construction of the dam. As we speak now, Bui, in about 2 months continuously, had to go for a bank overdraft just to pay workers because they didn't even have money. Not to talk of investment, just workers. You go to Greco, they are equally doing the same thing, overdrafts, to pay workers. It tells you how they have become very, very cash-strapped. Not because of anything, but by virtue of the fact that you have an agency who collects all the money and who decides that, look, me, I have said that I want to pay you X, I want to pay you Y, instead of what has been predetermined. And so, in my very humble opinion, I think that, yes, PURC, to a very large extent, what they have started doing under Ishmael, I think they are doing a very good job. They must say those orders that have been issued. I believe that Dubik, who is a lawyer, should appreciate that this is by the law. The law says if they issue this, we must respond. They should make the data available and let's all query the data and know as to how these monies are going. Because you see, look, something just to conclude, but I know you want to make me conclude. If you see the level of debt that are being piled as a result of the actions of ECG, already from the one we will definitely be filing debt because they cannot account for the power that they sell. That being said, even the money that people were even applying it to pay to retire some of the debts and some of the newly occasioned debts, we will not be in the situation that we are in. And it is because of the simple indiscipline of one organization.
Okay.
We find ourselves in this.
Thank you very much for your time, Edward Bauer. And Ben, very briefly, Ben, listening to Edward Bauer, is there anything to confirm from his point of view or from what he knows? And what do you also say has to be done going forward, briefly? Hello, Ben.
Sorry, I was muted. Yes. So I was saying that we all have a duty to ensure that the power sector is cleaned up. And that's why I always link its effect, the effect of the power sector to the budget. Because we are the ones who are paying for the inefficiency. Every citizen is paying either through fuel at the pump, or government is finding money somewhere in the budget to be able to pay for the inefficiency. So when we say ECG is inefficient, it's not just words. It has implication, it has impact on everybody else. And the earlier we fix that, the better it will be for all of us. So the directives that have been issued by PURC, we are keen to monitor to ensure that they deliver on them and they will be transparent with the public on the outcome of those directives. And even more, to be able to monitor the abuse of the consumer that is going on. As we speak today, ECG is quoting fees and charges that are not regulated. They cannot function outside regulation. And it's the function of and duty of the PURC to ensure that they don't do that. You can't charge me for a meter that hasn't been approved by the PURC. That is illegal. You cannot do that, but they are doing it. Meanwhile, the tariff also has investments that encompasses all these metering things. So why are they doing it and nobody's regulating it?
Edward was talking about what they had to pay the IPPs in excess of $300 million, and that they had done cities, and that they had done under 200. And I was referring to him the fact that we have information to the effect that they had done to the IPPs between August and December, they had done $305 million.
Yeah, so the point really is that whatever they have done is a portion of the debt. That is fundamental. All right? You have revenue requirement that you have to pay. And the arrangement that they have, even with the IPPs, is about 30 to 40% of how much you go to the IPP. So there is accumulation that is even still happening. So cleaning up the sector and accounting for the actual funds are important. The 120 million, I mean, it is in the that one is in the PURC report for the catch water for.
Okay. Edward again talks about the amount of power they are unable to account for. That appears to me not to be the exact figure you have in our discussion last week. He's talking about in excess of 30%.
Yeah, so the commercial and technical losses cumulatively is about 30%. I think the last year one was about 29, but before that it was about 30 to 31%. Beyond that also are collection challenges. So if you put all of that together, you are even close to 50% because the revenue requirement is a composite of what the power generated, transmitted, distributed should cost us versus how much you actually collect. So it's not just the cost of power that we are not able to collect, but what it also takes for that power to get your fridge or to get your television, because somebody has to transmit it, and that transmission is done at a cost. ECG itself has to distribute it, and it comes at a cost because they have employees, they have systems that they have to account for. All of that have cost attributed to them. So all of that cumulatively is what we are doing less than 50% of the revenue that they need. If you check PURC's publications and revenue requirement, they are supposed to do between 1.9 and 2 billion cedis every single month.
Okay.
And they are doing less than a billion.
All right.
It's only 1 month, a billion and 22 or so. So that is the scale of the other recovery.
Thank you very much. Thank you very much, gentlemen. I can see that we may have to once again revert to this subject because there are other angles that have triggered very important discussions, including the questions of the FX and suggestions of some sweetheart deals, which we have also been privy to some multiple sources of figures that suggest that nothing untoward has happened, contrary to the allegations that have been made. But it does appear that in the coming days we will need to revisit this. But Kwenka, having read and from where you sit, having been minister and reading all these reports, incomplete, and yet there are issues with it and we have to use it for debate.
I have told you this on this platform several times. See, the reportage by multiple media houses and individual commentary seek to draw conclusive determinations about fault finding in all these reports that are inconclusive anyway. And that is why we have to be very hesitant in our commentary and drawing conclusions, because it appears that we have even judged and convicted the ECG without actually coming to a final determination whether or not those findings have been defended successfully or etc. Now, I'm very worried that the young man is doing some wonderful things there with ECG, and yet we're not talking about those positive strides that he's making. We're just singling out some of these things which we call defects and taking him on and etc. Look at the recent things he did, moving to Parliament and other state institutions, very daring, very courageous. Let the money come out so that we'll be able to meet our commitments to keep the power on. All those things, we are not commenting on them. His level of commitment and courage.
We have commented on them. It is time to comment about this.
Yes, and this one, as I have indicated, it is very clear. I mean, there's no time actually, you haven't given me enough time, but it's very clear from the commentary we are running that we are drawing certain conclusions that will recant or eat back with the emerging facts that we are getting day in and day out. Because
I was mentioning, the issues of transparency with their dealings and the collections and so on has actually brought up a different thing where the one bank, for example, has been accused of dealing with them with the forex as a certain rate.
Yes.
And I have just seen figures, not just, I've seen figures from multiple sources, to be frank with you, that do not confirm.
Yes.
That are to the contrary of what is in the public.
That is what I'm saying. In fact, the ECG has been convicted without even being given any hearing at all. We haven't listened to them to explain their side of the story for us to look at it. All the reports that we get, we just use that as the basis to hang them. And I'm saying that we have all agreed there is an interim report. And remember that answers will be provided. As and when they are available, ECG will provide further answers, they will provide further accounts, they will provide further clarifications. And so it will be even the case that in the end, those faults that are alleged to have been found would have been perfectly answered in manners that we would not even be discussing the issue as we are doing. So let's give them the opportunity to explain themselves. And I think that they are doing a wonderful job. The ECG led by Samuel Dubeg is doing a very wonderful job trying to put our light, make sure our lights are on and all that in the midst of difficulties. We should criticize them. Yes, they are not beyond criticism. But at the same time, we should acknowledge their efforts and ensure that some of these things that we convict them even before giving them a hearing, we do not. So that at the end of the day, we'll have a very balanced reportage and then the integrity of the institution will be at.
Thank you very much. And tomorrow afternoon at 2 p.m., join me, have part 2 of my discussion on punishing lawyer misconduct. And we'll be joined once again by the director of the Ghana School of Law and director of legal education, Berima Yao, K. Opong, and Ahmed Musa on the law. Thank you very much. I'm Samson Lardy Anyenini. Have a good afternoon.